This lecture covers land use restrictions, starting with CC&Rs, or Common Interest Communities, beginning on page 752 of your textbook, Chapter 10. CC&Rs just stand for Covenants, Conditions, and Restrictions. They are private covenants that are used for large pre-planned communities, and they're often enforced by homeowners associations. So we're going to take a look at the first case, Nahrstedt v. Lakeside Village Condominiums Association, Inc., which is a classic case about the difference between the community's interests in enforcing CC&Rs and the owner's personal liberty, right? Or their privacy. So the facts of the case are as follows. In 1998, Nahrstedt purchased a condo in a complex, and she moved in with her 3 cats. The CC&Rs, which were recorded, stated, quote, "No animals, which shall mean dogs and cats, livestock, reptiles, or poultry shall be kept in the unit." So when the Homeowners Association found out that Nahrstedt had moved in with her cats, they demanded that she get rid of her cats. So Nahrstedt sued for a declaration that the pet restriction was unreasonable because her cats were indoors. And so as applied to her situation, she argued the pet restriction was unreasonable. The trial court sustained the association's demur. The California Court of Appeals reversed, and here, this opinion in your book is the California Supreme Court opinion, which upheld the validity of the restriction. The narrow issue in this case is whether pet restrictions that were contained in the recorded declaration is enforceable against Nahrstedt. And the court applied a California statute, and that California statute requires that courts enforce covenants, CC&Rs, that are in recorded declarations equally. They enforce them unless the CC&Rs are unreasonable. So the court defines unreasonableness as being wholly arbitrary, violating fundamental public policy, or imposing a burden on the use of the affected land that far outweighs the benefit. And so, unless Nahrstedt was able to show that the burdens that were on the property so substantially outweighed the benefits of the restriction, then they would need to be enforced against her. Now, the court noted that it would not use a case-by-case approach to decide unreasonableness. So they would look at the restriction generally without looking at the facts specifically that was before the court. And based on this general analysis, the court held that a CC&R prohibiting cats or dogs but allowing other pets is not arbitrary, that it was rationally related to health, sanitation, and noise concerns. So here is that test that I just spoke about. So this is the court stating that they're not going to use a case-by-case approach. They stated that the reasonableness or unreasonableness of a condominium use restriction is to be determined not by reference to the facts that are specific of the objecting homeowner, but by reference to the common interest development as a whole. So the standard sent out by Nahrstedt was pretty protectant over CC&Rs. Stated that when a restriction is contained in a declaration of a common interest development and that declaration is recorded, then that restriction is going to be presumed reasonable. And it would be enforced uniformly against all residents, right? Unless the restriction is arbitrary, imposes burdens on the use of lands it affects that substantially outweigh the restriction's benefits to the development's residents, or it violates public policy. So that's the Nahrstedt Standard. Now, if we compare the Nahrstedt Standard, to the Restatement Standard, we find that the restatement has perhaps a similar rule, right? So it states that a servitude is valid unless it is illegal or unconstitutional or violates public policy. Under this approach, the servitude violates public policy if it, 1, is arbitrary, spiteful, or capricious. 2, it unreasonably burdens a fundamental constitutional right. 3, it imposes an unreasonable restraint on alienation. 4, it imposes an unreasonable restraint on trade or competition. Or it is unconscionable. Okay. So let's move on to doing some CC&R problems. You can find these on page 762 of your textbook. All right, suppose the New Village CC&Rs contain the following provisions. Are they valid under the Nahrstedt test? And then I'd like you to compare that with whether or not it would be valid under the restatement test. Now, the purpose of these problems is to work on your application of law to facts. But for exam purposes, you will only need to worry about the restatement test. Okay. So, problem number 1. The CC&Rs contain the following provisions. Only college graduates may live at New Village. Let's start with whether or not they are valid under the Nahrstedt test. All right, let's take a look at the Nahrstedt Standard again. Okay. So Nahrstedt v. Lakeside Village Condominium Association Standard is, oh, there you go, sorry about that. When a restriction is contained in the declaration, it's recorded, so we're going to assume it's recorded. It would be enforced unless the restriction is arbitrary. Okay, so is the restriction arbitrary? Not necessarily, right? So it could be rational if the relationship is relevant to the, if there's a relationship between the reason to the purpose of the development. So the folks that run the development could argue that they're trying to attract like-minded residents, that maybe they have group activities that appeal to college students. It is a admittedly thin relationship here, but if we move on to the next line, right, so unless it imposes a burden on the use of the lands it affects that substantially outweigh the restrictions or benefits to development's residents. Okay, so it is a burden, right? Right, there's a burden there that they must be college graduates. And it does, perhaps, it would outweigh the benefits, except except for the fact that in this rule, there's the word substantially. And so based on the court's interpretation, it wouldn't substantially outweigh the benefit here, right? So if you read Nahrstedt with an eye to kind of what the court's position is in protecting these CC&Rs, you would see that the test was very different to the CC&Rs. So the majority strongly felt that CC&Rs should be able to stand unless there is some pretty solid reason, right? And you can see that when you read the dissent, right? The dissent essentially says that this means that the majority's decision means that as long as CC&Rs are filed, then they're going to be presumed to be valid, right? And so the word substantially here would likely make it so the court interprets the restriction as not substantially outweighing the benefit. Okay, so the final line here is, does it violate fundamental public policy? Well, it is not very socially forward or desirable for society to section off by education level, but the key here is fundamental public policy. And what is socially desirable probably doesn't arise to what is a fundamental public policy. Okay, so now, how do you think if we applied the Restatement Standard, the court would find about the restriction? Let's take a look at the Restatement Standard. So the Restatement Standard would presume that it was valid unless it was illegal, unconstitutional, or violating public policy. Well, there's nothing illegal or unconstitutional about it. It might be in poor taste, but it's not illegal or unconstitutional. What about violating public policy? Well, then we go back down to this explanation by the restatement that it violates public policy if it's arbitrary, spiteful, or capricious. Again, we said that this is an arbitrary, unreasonably burdens a fundamental constitutional right here. There's no constitutional right. Unreasonable restraint on alienation. There is nothing in this restriction that prevents the property from being transferred. And it doesn't impose an unreasonable restraint on trade or competition, nor is it unconscionable. So under the Restatement Standard, again here, the purpose of this is to show you that both the Nahrstedt and the Restatement Standard are pretty differential to the CC&Rs. So we start off with the assumption that the CC&R is valid. Let's move on to the second problem. Okay. While on the new village property, all residents must wear clothing made from natural fibers in order to help preserve our environment. Would this be upheld under the Nahrstedt test? Now this one here is a little bit more difficult, and so I just want you to focus not on whether or not you got this answer right or wrong, but whether or not you understood the standard. So this one would likely be invalid under the Nahrstedt test, and the reason it would be invalid is, let's go back to the definition for the standard. When a restriction is contained, there we go. So again, here, the first step is to look at whether or not the restriction is arbitrary. And here, the relationship seems to be pretty arbitrary, right? So there isn't really a, quote, rational relationship to the protection, preservation, operation, or purpose of the affected land. Now, you might be saying, well, having an adults or college educated only complex doesn't seem like it has a rational relationship to the land either. But if you look at that definition, which is on page 757 in Nahrstedt, that rational relationship is not only to the land, but also the operation of the land. So here, it's not clear how wearing clothing from natural fibers would affect the operation of the development, unless they could show that the purpose of the development, or one of the major factors of the development, was to create a community of folks that were trying to protect the natural environment. So that would be the only way that this could possibly be upheld. And without that proof, it would probably be invalid. So, let's see. Right, so we kind of fall short on the arbitrary, right? Now, what do you think? How do you think the Restatement Standard, how do you think the court would rule under the Restatement Standard? All right, so again, we start with it being valid unless it's illegal or unconstitutional or violating public policy. All right, so the question is it unconstitutional here? You could make an argument that your choice of clothing is protected as free speech. And so a requirement that you wear certain things would unreasonably violate constitutional right. And so therefore it would violate the Restatement Standard. Again, you can also show here that it would violate public policy if because it is arbitrary. Now, again, the caveat is unless the community is one that was created for the specific purpose of furthering the environment, right? So unless they're able to show that, then it would likely be arbitrary. Okay, let's move on to the next question. All right, so this third problem says that what if the CC&R, says that no one may watch television at New Village? Would this violate the Nahrstedt test? Now, your gut reaction here would probably be to say that there is no way that either the Nahrstedt test or the restatement would uphold this type of restriction. But you might be surprised to find that, at least based on my analysis, the Nahrstedt court would likely uphold this. And here's why. Okay, so is this arbitrary? Well, it does have a rational, even if it's a small relationship, with the operation and purpose of the development, right? You could argue that because these are condos with thin walls, that it would minimize noise. Perhaps it would encourage residents to engage in other activities. So as you might be beginning to see, that it's going to be difficult to find that restrictions are arbitrary based on the Nahrstedt test, right? All right, so then we go to the second question of whether the burden of the restriction outweighs the benefit. Well, there are many benefits to banning TV. Right, we kind of went over to some of those before to encourage people to participate in things other than television, etc. Well, what about the benefit of TV, right? So you could use TV for news or for educational programming or even entertainment, right? Let's not devalue entertainment. However, remember, the test is a pretty high one, and that is substantially outweighs. Substantially is pretty high here, and because we can make a list of benefits as well as the burdens, courts would likely find that it does not substantially outweigh the benefit. Finally, we go to the next question, which is there a fundamental public policy in favor of watching TV or having the ability to watch TV? And no fundamental public policy. Remember, these standards are high because of the use of the word substantially and fundamental. Okay, so we said that it would likely be enforceable under Nahrstedt. What about under the Restatement Standard? Would it likely be enforceable under the Restatement Standard? Well, let's take a look at the Restatement Standard. All right, so illegal, unconstitutional, violating public policy. Well, definitely not illegal. What about unconstitutional? There's no really constitutional protection to watch TV. You're not fundamentally, you're not expressing your freedom of speech, right? And then as far as violating public policy, again, it doesn't violate any one of these public policies listed. So I think what's so disturbing is that both of these tests really sacrifice privacy in the home or things that occur in the home in ways that we wouldn't think courts would uphold, right? We would think that courts would protect activities that happen in the home. Well, the logic behind these is that they're contracts, right? So people agreed to these restrictions, and they purchased property knowing about these restrictions, and so courts are much more differential and willing to uphold them because people contracted. They expected when they purchased the property that these restrictions would exist, right? So that is the justification for them. All right, let's go to our final problem. What about no animal shall be kept in New Village? Unit owner X has become blind and needs a guide dog. Would this still be upheld under the Nahrstedt test? Now let's go back to the Nahrstedt Standard. So the court has already found that restrictions against animals, owning animals on the property, were valid. And so under the Nahrstedt approach, they would enforce this restriction just based on the Nahrstedt approach. Because the Nahrstedt approach says, remember, that the facts of the specific owner are not relevant, right? They're not applying it, determining if it is valid on a case-by-case basis. What about this violating a fundamental public policy? Well, again, the courts aren't looking at the facts. Remember, the court held that they wouldn't make a determination on whether or not a CC&R or covenant is valid based on the specific facts of the case as applied, but on whole. Right. So now it would be invalid under the Fair Housing Act. Okay. So it would be invalid under the Fair Housing Act because it's a refusal to make reasonable accommodations. But under the Nahrstedt Standard, the restriction would still be upheld. What about the Restatement Standard? Well, if the court uses a kind of a generalized approach and they don't use a case-by-case approach, then the same result would occur when applying the Restatement Standard, right? So the Restatement Standard would uphold it as well, for the same reasons that the Nahrstedt Standard would have, and that is that they're not doing a case-by-case analysis as to whether or not the covenant is valid. But again, here the Fair Housing Act would apply, and the Fair Housing Act would be violated because it would constitute a refusal to provide reasonable accommodations to the person who has lost their sight. All right, let's discuss some defenses to, defense to CC&R enforcement. So the first defense we're going to discuss is that of abandonment, and we're going to discuss it by going over a case, Fink v. Miller. So Fink v. Miller is a case about wood shingled roofs. So the facts of the case are as follows. Fink and Miller purchased residential lots in a subdivision, and many of the lots were burdened by a covenant which required that they build wood shingles on the roofs. And they said that any new structures that affected the roof would have to be approved by an architectural review committee. Well, during a period in the 80s, let me see if I have the dates here. So between 1985, before 1985, the Homeowners Association was under the mistaken belief, or at least they testified this, they were under the mistaken belief that the CC&Rs had been amended and that they could have tile roofs as well. So by the end of 1985, 29 houses had been built in the subdivision that had 21 of which had fiberglass shingle roofs, and only 8 of those had wood shingle roofs. So in 1991, the Millers submitted a request to have tile or fiberglass shingles on their home, and the committee denied that request. So Miller and her husband decided to just go ahead and do it anyway. Fink, who's one of the residents, sued to enforce the wood shingle roof covenant. So at the point of the case, 23 out of the 81 homes in the subdivision did not have wood shingle roofs. The trial court granted summary judgment for the Millers, and here we're reading the Utah Court of Appeals decision where they affirmed. All right. So the what is at issue is whether or not the CC&R regarding the covenant regarding wood shingle roofs had been abandoned. So the test that is applied by the majority for abandonment is when an average person, upon inspection of a subdivision, can readily observe sufficient violations so that they will logically infer that the property owners neither adhere to nor enforce the restriction. So the key pieces to this test are upon inspection of a subdivision, right? Upon inspection. So that means it's something that has to be observable upon inspection. And the violations have to be sufficient in number. Sufficient so much so that a reasonable person would conclude that the CC&R had been abandoned. Excuse me, went a little bit too fast there. So the court says the way to go about this, applying this test, is to first analyze the violations in, as far as their number, nature, and severity. And if, by looking at the number, nature, and severity of the violations, you can determine whether or not the test can be met, then you don't need to go any further. If it's still in doubt after looking at the number, nature, and severity of the violations, then the court would consider two other factors, which is A, prior enforcement efforts, and B, possible realization of benefits. Again, that's A, prior enforcement efforts, and B, possible realization of benefits. So, in applying this approach to the facts of the case, the court found that because 23 out of the 81 homes did not have wood shingle roofs, that was sufficient enough in number and nature that it must be concluded as a matter of law that the restriction had been abandoned. The court also did consider the purpose of the restriction, and the purpose of the restriction was to maintain the natural environment, to promote uniform development, and to maintain property values. Because things had changed, right, that was no longer the most environmentally friendly way to create a roof, right, because there was potential for fire damage. Moreover, there were so many homes without the wood roof, without the wood shingle roof, that the court found that you can't really argue uniform development here anymore. So although other aspects of the CC&R could still be enforced, the court found that in this case it could not be enforced. A couple points of discussion that are worth mentioning. So if you take a look at page 767 in your book, there is a short hypothetical under B, applying Fink, that is based on Western Land Co. v. Trokoloski. So in that hypothetical, there was a tract of 100 houses that prohibited a sculpture, and the owner erected a very bright yellow 50-foot tall statue of a duck in the front yard. But all other owners complied with the restriction. So a neighbor complained and sued about this duck statue. And the question is, has the restriction been abandoned? Well, the answer is no, right? So a single violation is not enough to find a violation based on the tests put forth in Fink, the Fink standard, right? Remember, because we talked about the need for numeracy, right? The number of violations. And you may wonder, well, what about it being a severe enough, right? Because the court said first we'll analyze violations as to their number, nature, and severity. So would this be sufficiently severe? And the answer is yes, it might be severe, but even with such severity, it is very rare and unusual for a single violation of a CC&R to constitute abandonment. Okay, very rare for a single violation of a CC&R to constitute abandonment. Let's say instead the facts were a little bit different. Now take a look at page 768 of your book under letter D, where it talks about exploring abandonment. And it gives you the facts of a case, Travesos v. Stoma. And in this case, there were restrictions that prohibited all metal roofs, right? And 2 of the 7 roofs in the complex violated the covenant. But the court found that no abandonment occurred. Now, the court noted while the metal roof on the defendant's store could be seen, it was not visible from the front of the building. So my question to you is Travesos consistent with the finding in Fink? And the answer is that it is. So the court held that no abandonment occurred, but if we apply the Fink test, we can see that it requires there to be a readily observable condition. And so the court did not err or differ from the Fink court because the metal roofs could be seen, but they were not visible from the front of the building. So they were not readily observable, right? So you have to make sure that when you're looking at a fact pattern, that you can readily observe the difference. The same thing would go if the fiberglass shingles that were installed looked exactly like the wood shingles, and nobody would know by looking at them that they were different. In that case, there would not be readily observable violations. So you need to make sure that the facts suggest that the observations were readily observable. All right, this next case that we're going to talk about discusses another defense to CC&Rs. I forgot to put a little placard or a little signpost here for you, but make sure to note that this case talks about another defense to enforcement of CC&Rs. And that defense is changed conditions. So we already went over abandonment as one defense to enforcement. Now the second is changed conditions. So the case is Vernon Township VFD versus Connor. Facts of the case are as follows. In 1947, the subdivision entered into some valid restrictions, one of which was a covenant that prohibited the sale of alcoholic beverages. Many years later, in 1997, the Vernon Township Volunteer Fire Department purchased a parcel within the same subdivision. Now, they wanted to build a new fire station and a social hall. The social hall, the profits from the sale of the alcohol, would then help finance the fire department. Now, the fire department was on constructive notice of the alcohol restriction. Remember, constructive notice means that the covenant has been recorded. But the fire department claims that they didn't receive actual notice until 1999. So that means that although it was recorded, they didn't know about it, right? Now just note that in and of itself is not a defense because constructive notice is sufficient. But it helps kind of explain their behavior, right? So because they didn't receive notice till 1999, they had already spent $790,000 building the new fire station. So they went to each of the owner of the remaining remaining lots in the subdivision, and they asked them if they could voluntarily agree to release the fire department from the restriction. And 68 of the 77 parcels of land agreed. 9 owners of parcels refused. 6 of those then decided to bring suit to enforce the covenant. The fire department sued to quiet title and for declaratory relief, arguing that the covenant should not be enforced because conditions have changed. The trial court found for the defendant owners, but the Superior Court reversed it. The decision in the textbook is the Pennsylvania Supreme Court, which reversed and held that the restriction was indeed enforceable. All right, so first let's start by talking about why the Vernon Township Volunteer Fire Department decided to raise a defense based on changed social conditions instead of abandonment. Well, there's no evidence in the fact pattern that suggests that the restriction had been abandoned, right? Because to be abandoned would mean that there would be evidence of alcohol being sold on the premises, and there's no efforts to enforce against those people that were selling alcohol, right, or businesses. So that is why the fire department sought to defend against enforcement using the reason of changed conditions. Now, you can argue that conditions had changed in 3 ways. That the first way was that alcohol became more socially acceptable, given in 1938 when they 1946 when they adopted the restriction. It was only about 13 years after the prohibition had been repealed, right? So the 1946 restriction could have been a result of the kind of lingering anti-alcohol or temperance movement sentiments, right? The second condition that had changed was that there were 3 establishments that were serving alcohol within a 2-mile radius of the subdivision. And the third condition that you can argue had changed was that most of the vast majority of the owners did not want to keep that restriction. So why did the court find that the changed conditions question had not been met? Well, in order to discharge a covenant, the burden of proof is on the fire department to show, 1, that the original purpose of the restriction has been materially altered or destroyed by changed conditions, and that 2, a substantial benefit no longer extends to the appellants by enforcement of the restriction. And although we went over how conditions have actually changed, the court found that the original purpose of the restriction was still valid, right? That the owners benefit, which this was largely a residential neighborhood, so the residential owners benefited from there being alcohol consumption, decrease in rowdiness, et cetera, et cetera. So, and the purpose of the covenant still existed, right? And so because of that, the court found that the elements defined a changed condition and abandoned the restriction did not exist, right? Now, this standard that is presented in Vernon is the national approach to analyzing whether changed conditions should allow for a defense against enforcement. So it is a national standard. So here's a thought question. The restriction in Vernon Township was not subject to an amendment even by a supermajority of residents. Should a court enforce a restriction that's not subject to amendment even if an overwhelming majority of the residents want to change that restriction? What do you think? There's no right or wrong answer here, but I just want to suggest that there was another approach the court could have taken. The court could have invalidated the restriction and instead just compensated the complaining owners with damages. Damages based on decreases in property or noise or traffic or anything like that. They could have compensated them with money damages, but allow the restriction to be removed because the majority of landowners didn't want that restriction anymore, and there was no mechanism for amendment. Now, this next case that we're going to discuss, Schaefer v. Eastman Community Association, is examining whether a unit owner who disagrees with a decision made by a homeowners association can successfully challenge that decision, that discretionary decision, in litigation. So can a unit owner that disagrees with a discretionary decision made by a homeowners association sue in court? And the facts of the case are as follows. So the defendant, Eastman Community Association, is a homeowners association. And homeowners associations, remember, are primarily created to enforce CC&Rs. The Eastman is a community that was built as a recreational community in New Hampshire. And one of the amenities that were originally included was downhill skiing at Snow Hill. This was advertised. The resident relied on these materials when deciding to purchase their units. However, most residents didn't use Snow Hill. And in 1999, the board, the Homeowners Association, decided to vote to close Snow Hill. And they wanted to sell the facility. The plaintiff owners, represented by Schaefer, sued for an injunction to prevent the closing of Snow Hill and for damages. And the trial court ruled for the plaintiffs, but the New Hampshire Supreme Court reversed that decision and ruled for the Homeowners Association. In deciding what rules to apply to this case, the court chooses to follow and use contract law, right? It states that the declaration is a contract and notes that the association is a nonprofit, and so they decide to treat it as if the declarations and agreements are contract. And as such, They identify two issues or potential issues when the court is called upon to assess the validity of the action taken by a board of directors of a homeowners association. It says, first, the court must determine whether the board acted within its scope of authority, and second, they must determine whether the action reflects reasoned or arbitrary and capricious decision making. Now, the court notes that what is at issue in this case is only the first, whether the board acted within the scope of authority. The homeowners did not raise the second issue of reasonableness. Why do you think that might be? Well, if we were to take our best guess, the reason they probably didn't raise the reasonableness standard is it probably was not reasonable to keep it open, right? It was probably not financially feasible. Use of the slope was down. It probably made more sense financially to actually sell it, right? So the second prong here was not raised. It was only what was at issue was the first, whether or not the board acted within its scope of authority. So to determine whether or not the board acted within its scope of authority, the court uses contract interpretation principles and takes a look at the CC&R, the declaration, which is what governed the board, and looked at the language of the declaration. And the court felt that it should interpret as broadly as it could the provision in the declaration, and said that so long as the board's action does not contravene either an express provision of the declaration or a right reasonably inferable therefrom, it will be found valid within the scope of the board's authority. All right, so as long as the act does not contravene either an express provision of the declaration or a right reasonably inferable therefrom, it will be found to be valid within the scope of the board's authority. So therefore, the court held that the authority of the homeowners association should be broadly construed under the document that created the board. And in this case, that meant that the board had the authority to close an amenity because it was a reasonable decision that was made by the board based on their powers. Interesting thought question. So is a board of a homeowners association more like a board of a corporation or like a city council? And does this affect the level of review that a court should give the decisions made by the homeowners board? Take a moment to think about that and write up what you think. There's no right or wrong answer here. I would argue that it's more like a board of a corporation for a couple of reasons. Number one, it's actually set up like a nonprofit corporation, in which case there is a board of directors that are making decisions about that entity. Also, the court applies contract principles, right? Now, you could argue that it is more like a city council because folks are elected for these homeowner association positions just like they would be for a city council. However, in my opinion, city council is more tied with public policy considerations, whereas a board of a corporation is more so invested in carrying out the purpose of the corporation, which is in making financial profits, but in the case of a homeowners association, their true purpose is to enforce the purpose of the community, right? So I would argue that it's more like a board of corporation, but you could have argued either way. I think that in regards to the level of review that a court should give the decisions made by the homeowners board, the election or the electability of officials does give homeowners or the electability of the members of the homeowners association, or the board rather, sorry, does give homeowners the ability to elect and therefore get rid of folks that they may not agree with their policies or politics or their rulings, right? And so you could argue that if we view it more like a city council where there's elections, that warrants that the court should give the decisions made more deference, whereas if it operates more like a board of a corporation, then maybe we do need some checks by the court, because the shareholders, or the homeowners in this case, they would need, they don't have as much power to replace the board of directors as they would an elected official, theoretically. All right, so we're going to go over one more case that deals with a similar issue. Again, it is a case that examines the ability of a unit owner to challenge a discretionary decision that's made from the homeowners association board. The case is Fountain Valley Chateau Blanc HOA v. the Department of Veteran Affairs. The case are as follows. Cunningham entered into an installment land contract with to purchase the townhouse in Fountain Valley Chateau Blanc development. And the CC&Rs provided that the owners were required to, quote, maintain the interior of their residential units, including the interior floors in a clean, sanitary, and attractive condition. In 1994, the Homeowners Association sued Cunningham, arguing that he violated the CC&R and created a fire hazard because of the junk and paper that he had stacked all over the place. Now, housing code and fire inspectors didn't find any hazardous conditions on the property, but the association continued its litigation, even sending him a long list of chores that he needed to do, like clear up his bed of wallpaper and books. Cunningham then filed a cross-complaint against the association, arguing that their actions were unreasonable. The jury returned a verdict for Cunningham, but the judge granted a new trial motion stating that the association had acted totally reasonable. This is a California Court of Appeals decision, and they treated the case de facto, de novo, and reverse. Now, the issue, what was at issue in this case was whether or not the actions of the board were reasonable. To that, the court states the following. The association's rather high-handed attempt to micromanage Cunningham's personal housekeeping, like telling him how he could and could not use the interior rooms of his own house, clearly crossed the lines and was beyond the purview of any legitimate interest it had in preventing undesirable external effects or maintaining property values. So, the court here focuses on its standard of reasonableness as a legitimate interest in preventing undesirable external effects or maintaining property values. approach differs from the Nahrstedt approach a bit. Interestingly enough, these cases were both in the same jurisdiction, and the Nahrstedt decision was a Supreme Court decision. So the Fountain Valley Court arguably could have applied the Nahrstedt decision, right? So the Nahrstedt decision allowed CC&Rs to limit how a resident used the inside of her home by prohibiting her from keeping cats. And Fountain Valley took the position that the home is a resident's castle and the HOA has no business micromanaging inside the home. Now, if we apply the Nahrstedt test here to the Fountain Valley facts, we could have made an argument that the burden of the restriction did substantially outweigh the benefits to the development's residents. So if the court had just used that test that was in Nahrstedt's, they might have still come out with the same decision, right? Because arguably the burden of the restriction, which interferes with the privacy within one's home, right, substantially outweighs the benefits of the development's residents, which appear to be none, right? And that's what the court was saying, that it didn't cause any exterior issues. The court seemed to be concerned with the scope of the restriction as it was written, but it didn't articulate that the scope was written too broadly. It tried to avoid enforcement of the article instead under the idea that it couldn't possibly be interpreted to apply in this manner, right? Now, this differs because the court here seems to be looking at the facts of the situation under Nahrstedt. They would have had to look at the general application. But the court here was careful in making their decision narrow, and may have written it as such so that it did not tag on to, or they did not need to distinguish from Nahrstedt. So that's probably the reason that they chose the approach that they did. That's it for CC&Rs. Our next topic is going to be nuisance.